Kentucky, Inc. for an adjustment of the natural gas rates, approval of new tariffs, and all other required approvals, waivers, and relief. My name is Amy Covage, and I am Vice Chairman of the Public Service Commission. I will be presiding today. Joining me is Commissioner Mary Ann Butler. For those in the hearing room, please set your cellular phones to silent mode or turn them off. In light of recent increases in COVID cases, we continue to take precautions, including limiting the number of persons in the hearing room, social distancing, and cleaning the witness table between witnesses. Disinfecting wipes have been placed at the witness table, so we ask each witness to please wipe down the witness area with the wipes at the conclusion of your testimony. For witnesses who will testify by video and counsel who will participate by video, to assist with audio clarity and avoid feedback issues for the video conference hearing, please mute your microphone and turn off your video if you're not speaking. If you use a phone for the audio and a computer for the video, turn off the computer audio so that there's no feedback. If you are in a room with several people on their own computers, turn off the audio for all but one computer. If another participant is in a nearby office, please close the door between. If you need assistance in finding the correct microphone in the GoToMeeting software platform, there is a little gear icon. You can click on that and find the microphones and connect. And please alert the Commission if you are experiencing a technology failure that prevents your participation at any time in the proceedings. Attorneys should contact staff at the previously provided cell phone number. Again, the hearing today is for the purpose of taking evidence on Duke, Kentucky's proposed gas rate adjustment. Now we will have the entry of appearance of counsel, first for the applicant.
Thank you, Your Honor. On behalf of Duke Energy Kentucky, my name is Rocco D'Ascenzo, 139 East 4th Street, Cincinnati, Ohio. Appearing with me today are David Sanford and Allison Honecker from Goss Sanford Law Firm.
For the Attorney General.
Good morning, Vice Chairman. Good morning, Commissioner Butler. John Horn from the Kentucky Attorney General's office. And joining me online is Larry Cook from our office. And Madam Vice Chairman, Mr. Cook will be kind of running point for the Attorney General's office in this case.
Great, thank you. For Commission staff.
Good morning, Nancy Vinsel for Commission.
I've been advised that public notice has been given and filed into the record. Is that correct?
Yes, Your Honor.
Thank you. Are there any outstanding motions?
Yes, Your Honor, I know there's several outstanding confidentiality motions that will be addressed soon.
Okay. Any other motions from the applicant's perspective that we're missing?
No, Your Honor.
Thank you. Should anyone from the public like to provide the Commission with public comments, instructions to call in are located on our website, psc.ky.gov. The phone lines will remain open for several minutes at the start of the hearing and close if there are no callers or after everyone has had an opportunity to speak. Should you call in, please state your name and address for the record before making your statement, and please keep your comments to 5 minutes or less. If there is more than one caller, please be respectful and allow one person to make a statement at a time. And comments may always be submitted by email at the email address on the PSC's website at psc.ky.gov. If you do provide a comment either by email or by mailing it to us, please reference the case number 2021-00190. I think it's my understanding that no one has called in for public comment. Is that correct, Ms. Vinsel?
That's correct, Vice Chairman.
Okay. Well, at this time, we will move forward with the presentation of evidence, and I believe, Mr. D'Ascenzo, you will be taking the first witness.
Yes, Your Honor.
You may call.
Thank you. For our first witness, Duke Energy Kentucky calls Amy Spiller.
Good morning.
Good morning. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Could you please state your name and address for the record?
Certainly. It's Amy Spiller. My address is 139 East 4th Street, Cincinnati, Ohio, 45202.
Okay, counsel, you may examine the witness.
Thank you, Your Honor. Ms. Ms. Spiller, would you please state your title for the record?
Certainly, State President, Duke Energy Kentucky and Duke Energy Ohio.
And Ms. Spiller, I saw that you had a binder in front of you. Would you please identify what you have with you?
Absolutely, Mr. D'Ascenzo. I have a copy of the direct testimony I filed in this proceeding on June 1 of 2021, as well as discovery responses for which I was responsible either in full or in part. And additionally, I have before me a copy of the joint stipulation and recommendation filed in this proceeding, as well as our application.
Thank you. And so, did you cause to file direct testimony and responses to data requests in this proceeding?
I did.
And do you have any changes or corrections to either of those documents?
I do not.
And so if you were asked those same questions today, would your answers be the same?
They would.
And is it your intention to have those documents entered into the record of this proceeding?
It is.
Thank you. Your Honor, the witness is available for cross-examination.
Thank you. I guess we'll go to Mr. Cook on behalf of the Attorney General.
Yes, Vice Chair, the Attorney General has no questions.
Okay. And we will move to Ms. Fensel.
Good morning, Ms. Spiller.
Good morning.
I have just a few questions for you. As I'm sure you're aware, the natural gas prices have set new record highs recently, highs that we've not seen since about 2010. So what staff's questions right now are, can you address what impact these high gas prices will have on Duke, Kentucky? Particularly what planning is going on now to address the high prices?
Certainly, and I would agree with you that the commodity cost is more expensive now than we have seen in recent history. That direct impact to individual Duke Energy Kentucky customers is unknown. Much of that impact will be determined by the weather, just how cold it might be this winter, as well as individual usage. That said, we are very much aware of the circumstance and have initiated a very comprehensive engagement plan. Among other things, we want to make sure our customers are aware so that they can individually prepare for the winter heating season. So we're sharing tips and tools on what they can do to make their homes more energy conservative, if you will. We're also engaging with external networks that we have relied upon throughout the pandemic to inform our customers of available assistance. We know there are more assistance dollars today than there were in prior years. Want to be sure that they're aware of those, as well as those other existing programs, whether it be LIHEAP or our Home Energy Assistance Program. Additionally, we are reminding customers of opportunities that they have with the company, such as budget billing, so that they can enable some more predictability month over month with their bills.
And going one by one, when you talk about customer awareness, not only of the impact, what they can do, and then budget billing, is that through, say, bill inserts, through Duke's website? Could you please tell us a little more about how you notify customers?
Certainly, it will be a multifaceted approach, so we will use what's available on our website. We will also engage external networks, so I think about the Northern Kentucky Community Action Agency. I have gone on radio and even on some local TV shows to remind customers of available sources of aid and what they can do. So we will continue to engage again in what will be a very multifaceted outreach program for customers.
Thank you. And thank you. Yes, my next question was going to be about the external network, so thank you.
Certainly.
And my next question really builds upon the financial assistance to customers. And let me give you a little background. We know that some of the investor-owned utilities in particular have plans so that if someone receives a pledge of payment from a organization, that the late fees are waived for a certain amount of time. So what my question is, does Duke waive any late payment charges for any customers who receive a pledge of assistance say from Northern Kentucky Community Action Agency?
That would be on an individual basis with that opportunity, and I do know that we are working with the Northern Kentucky, it's KYADD, Area Development Association, so the Northern Kentucky Area Development Association, with the grants that they have through HUD. So we have a certification there with respect to pledges that may be provided to our customers.
Would Duke consider adding a provision to its tariff or its customer bill assistance program to include something such as waiving a late fee if there is a pledge of assistance outside of, say, Waive?
Yeah, it's certainly something that we would consider. I do know that late fees typically are an adjustment to the revenue requirement, so to the extent that those are being waived, there might need to be just some adjustment as we think about the offset to the revenue requirement.
Staff has nothing further.
Thank you.
Commissioner Butler?
No questions.
Okay. Good morning, Ms. Spiller. Thank you for being
Morning.
here. Are you the person I need to talk to about the short-term incentive plan, or will that be another witness?
That would be another witness.
Okay, who is going to be the best person for me to ask about that?
I'm going to look at my notes if I may,
Oh, of course.
just in the back of my testimony, ma'am. I believe that would be our witness, Jake Stewart.
Okay. And then the rider for the pipeline modernization rider,
Yes.
would that be you or will that be another witness?
It may depend on the question. I'm certainly willing to do my best. I also know that we have Sarah Lawler, who could answer some questions for you regarding the mechanics of the rider, and then Brian Weisker from an operations standpoint.
Okay. Well, let me just ask you, just in a general sense, what do you envision being a part of the pipeline modernization mechanism rider?
I would envision that the infrastructure investment we have planned with respect to our AM07 pipeline would be the type of project that would be included in that rider.
So when you say type of project, you are intending that it not be limited to the AM07 pipeline, but that would definitely be included. Is that fair?
That would be, yes, ma'am, that would be included. The anticipation is that this rider mechanism would be one that would allow us to recover for investments that are required under Femce regulation.
Can you be any more specific about the type of investments under Femce that you're envisioning here, just so I can conceptualize a little, because that feels pretty broad.
Femce regulations are very, very complex and I would say far-reaching, but a lot of it simply has to do with the integrity of the pipelines. There are particular requirements that Femce has of pipeline operators, so certainly making sure that we are allowed to adhere to Femce regulation, and some of that may be with respect to the ability to test those lines in terms of maximum operating pressure. That would be one of the elements, and certainly the AM07 pipeline is one that does require upgrade so as to comply with the Femce integrity and safe operating protocol.
Okay. So you would not just be considering pipeline upgrades as part of the rider, but also the testing that would be undertaken to see if a pipeline needs to be upgraded?
So can you rephrase that?
Yeah, that was very poorly worded. And I don't want to, I'm trying to avoid asking you a question that requires a legal conclusion because it's not fair to you and your lawyers would be very unhappy with me if I did that. Typically, like upgrade projects are going to require, in most cases, a certificate of public need, public necessity and convenience. And I understand that those types of projects you would envision being as part of the rider. Is there other ongoing pipeline modernization work that wouldn't need a CPC in that you would see as part of this rider? To the best of your ability to answer that.
It potentially could be. Certainly if there are If there are projects that do not require a CPCN because it is an ordinary extension, if they are prompted by requirements with Femce, there is the potential for inclusion within this rider. I would note, though, that the rider is subject to annual caps. I think will influence somewhat the investments that we do advance for inclusion within the rider mechanism.
That's all the questions I've got. Mr. DeCenzo, do you have any redirect?
Just one. Ms. Spiller, do you recall the question about the rider PM, well, about the government mandate rider, and you had mentioned that it was subject to annual caps. Is that annual cap part of the stipulation and settlement?
Oh, yes, sir.
Okay, that wasn't part of what was in our application.
That is correct.
Okay, no further questions.
And does anyone else have any follow-up questions? Hearing none.
No questions from the AG.
Thank you, Mr. Cook. Hearing none, witness may step down, if you don't mind wiping down.
Oh, certainly.
And I presume that Ms. Spiller will be staying around, or do you want to ask for her to be excused?
If she could be excused, we would request that she be excused.
Does anyone have an objection to Ms. Spiller being excused?
What I
No.
would want to know is if Ms. Spiller will be staying around in case of recall, if something should come up that someone refers to Ms. Spiller.
I don't know what Ms. Spiller's obligations or other plans were for today. I don't know if she's planning on staying around, that would be fine. If she was planning on going back, if there is the ability to get her back on the go-to-meeting, if there is a reason to ask questions later, would that be okay, Ms. Denzil?
That would be acceptable.
Is that okay with you, Mr. DeCenzo, Ms. Spiller?
Yes.
Okay. Then she may be excused,
Okay, thank you.
subject to recall. You may call your next witness.
Thank you, Your Honor. For our next witness, Duke Energy Kentucky calls John Spanos.
Mr. Spanos, can you raise your right hand? Do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
I do.
Could you please state your full name and address for the record?
My name is John J. Spanos. My address is 207 Senate Avenue, Camp Hill, Pennsylvania, 17011.
Mr. DeCenzo, you may ask your questions.
Thank you, Your Honor. Good morning, Mr. Spanos.
Good morning.
Would you please state your position and company, please, for the record?
Sure. I am president of Gannett Fleming Valuation Rate Consultants, LLC.
And did you cause to file direct testimony and responses to data requests in this proceeding?
Yes, I did.
And do you have copies of those documents in front of you?
Yes, I do.
And do you have any other documents in front of you?
I have the depreciation study that was filed in the last proceeding that was also included in this proceeding.
Thank you. Do you have any changes or corrections to any of those documents?
No, I do not.
And so if you were asked the same questions today, would your responses then be the same?
Yes, they would.
And is it your intent that those documents be submitted as part of the record in this proceeding?
Yes.
Thank you, Your Honor. The witness is available for cross-examination.
Mr. Cook, do you have anything on behalf of the Attorney General?
Vice Chair, no questions.
Okay. Ms. Fensel?
Staff has no questions.
Commissioner Butler?
No questions.
And I have no questions. So I'm assuming there will be no need for redirect.
Thank you, Your Honor. May the witness be excused.
Any objections?
No objection.
Any objection, Mr. Cook?
No objections.
Okay, well, you may be excused.
Thank you.
Thanks.
Morning, Your Honor. We call Sarah Lawler as our next witness, please.
please raise your right hand? Do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
Yes, I do.
Okay. Could you please state your name and address for the record?
Yes. Good morning. It's Sarah Lawler, 139 East 4th Street, Cincinnati, Ohio, 45202.
Okay. Counsel, you may examine the witness.
Thank you, Your Honor. Good morning, Ms. Lawler. How are you today?
Good morning. I'm good. How are you doing?
Good. Would you please state your title and your full name for the record, please?
Sure. Sarah Lawler, Vice President, Rates and Regulatory Strategy for Duke Energy, Ohio, and Kentucky.
And did you cause testimony and supplemental testimony in responses to data requests to be filed in the record of this proceeding?
I did.
Do you have any corrections, changes, edits to those data request responses or testimony?
I do not.
If I were to ask you the same questions, would your answers be the same?
They would.
What materials did you bring with you to the witness stand today?
I have my direct testimony and data requests that I sponsored. I also have a copy of the stipulation and my supporting testimony, supporting the stipulation, and then I also have rebuttal testimony.
Is it your desire and intent to have your testimony, your supplemental testimony, and your responses to data requests to be incorporated in the record of this hearing?
Yes, it is.
Thank you, Your Honor. Tender the witness for cross-examination.
Mr. Cook, do you have any questions for this witness?
No, the AG has no questions for this witness.
And Ms. Fensel?
Yes, we have a few questions. Good morning, Ms. Lawler.
Good morning.
In the settlement, one of the provisions or agreement terms is a proposed regulatory asset for the non-recurring developmental costs for both the new and the old customer information systems. So just to be clear, is Duke requesting that the commission approve Duke to establish a regulatory asset for those costs, the customer information service costs?
Yes, that is our request, correct.
And if the commission were to approve the regulatory asset, would Duke book a regulatory asset for the costs included during the test period or for some other time period?
So the regulatory asset would ultimately include the actual costs that were incurred.
And this last question is really going to be a post-hearing data request,
Okay.
which staff will follow up with in writing. But as you may or may not know, the commission traditionally approves a regulatory asset upon a finding of one of four, at least one of four particular criteria. An extraordinary non-recurring expense that could not have been reasonably anticipated or included in the utilities planning, an expense resulting from a statutory or administrative directive, an expense in relation to an industry-sponsored initiative, or an extraordinary or non-recurring expense that over time will result in a saving that fully offsets the cost. So in our post-hearing data request, we're going to ask which of these particular criteria is applicable to the requested regulatory asset.
Okay.
Now, in what was the government mandate rider and is now the pipeline modernization mechanism, Duke had requested the rider before it requested the CPCN for the AM07 project. Can you explain why they were not either requested in tandem or the CPCN requested first?
So when we first requested the rider GMA, it was intended to be a placeholder for these types of investments and also for tax changes, which we subsequently withdrawn in settlement. But, you know, at the time that we made this rate case filing and requested the placeholder rider, we weren't at the point where we needed to file the CPCN for these investments. I think that the first phase is estimated to go in service at the end of 2023. And so it would be our intention, I think, to file a CPCN probably in the spring of next year in order to make sure that we've got that filed in time for approval before we advance construction. So it's really just a timing issue.
My last group of questions is, I suspect the vice chair will follow up on, but I'm going to get started with this. Are there capital costs not associated with the AM07 pipeline that would be included in the PMM rider?
Can you repeat the question?
Sure. I guess what I'm really asking is, in terms of the rider, will it be limited to only the AM07 pipeline project, or will there be other capital costs that Duke would seek recovery for in the rider?
So right now, AM07 is the only pipeline project that we have identified to propose to be included in the rider. You know, to the extent over time, issues arise that might warrant other capital projects that would be needed to comply with Femce regulations, we may look to considering whether or not we would propose to include those in the rider. But I will say also that, as Ms. Spiller mentioned, we've agreed to caps on the rider, and I don't believe, you know, we've done some high-level estimating of what the AM07 would do in terms of revenue requirement. With those caps, there would not be much more to include in the rider, you know, to get us to those caps. You know, to the extent that we were over the caps, however, we have requested this deferral authority, so we would look to do that. But right now, we haven't identified any other projects at this time other than AM07.
And given that there is a potential for other capital costs to be included, would those costs be accounted for after they're installed or the construction is completed? Or would that type of a cost be included in the forecasted filing?
So we would not include anything in the rider. If it required a CPCN, nothing would go in the rider before filing the CPCN. If there were a project that didn't require a CPCN, and we knew that we needed to make the investment and we thought that it qualified, the plan would be to include it in that rider filing that we would make, say, in July. And in that rider filing in July, say, of '22, for example, you would be able to see all of the projects that we plan to include in that 13-month average forecasted test period. But yes, I guess technically, to the extent we didn't need a CPCN, that might be the first time that you would see us, propose to include something in the rider.
Oh, and again, in that July
Correct.
annual filing?
Correct.
Staff has nothing further.
Commissioner Butler?
No questions.
I have just a few, just to follow up on Ms. Femce about the rider, shockingly enough. Do you have criteria in mind for identifying projects that you would feel are eligible for the rider, the way the stipulation is drafted now?
It's our intention to only include any capital investments that are required as a Femce.
Okay, and I'm sure you heard me ask Ms. Spiller, that's very broad to me. Can you put any more detail or criteria in that?
Mr. Weisker might be able to better answer that question. I don't think that I could tell you any more specifics in terms of what the Femce rules require, so he might be able to answer that better.
Okay. And I believe you said to Ms. Femce, or you testified, that at this time, it's only the AM07 that is projected for this rider. You're not foreclosing that other projects could come up, but right now, that's the only one that the company has in mind. Is that correct?
That's correct, yes.
How did you come up with the cap?
So we had conversations with the Attorney General's office during settlement about what both parties would consider reasonable, trying to get to a reasonable rate increase for customers over time. We have done some high-level revenue requirement calculations specifically on AM07 only, and based on those, again, I'll say high-level estimates, we feel like the 5% is something that's reasonable.
and this may show my newness to this whole process, but if you max out in a year, have you calculated what that would mean for the average customer's bill?
So the 5% increase would be an annual increase, starting with a baseline. And so in year one, in 2023, for example, we wouldn't increase rates for more than 5%. The next year after that would not increase rates more than 5%, and therefore. But again, I'll say, high-level analysis on AMO7, we will be under the 5%.
Okay.
So we haven't done any other calculation then, because there wouldn't be anything
Okay.
in excess.
Are you proposing to include any just periodic monitoring and testing of the pipelines that you would be doing pursuant to regulatory requirements in the rider?
We aren't proposing to include any O&M expenses. It's just capital. So I believe most of that type of periodic testing would be O&M, and we're not intending to include that. That would be more base rate recovery at the time of the next rate case, if there was anything.
That is my last question. Mr. Sanford, do you have any redirect?
Just a couple, Your Honor, if I may. Ms. Lawler, you were the witness who sponsored the stipulation settlement agreement, correct?
Yes.
Okay, so tell me, was there a provision in there that related to the proposed cost of the customer information system? Do you recall?
Yes.
Can you explain what that provision is?
So the costs of the customer information system, and we're talking about the new, the O&M that we are proposing to establish as a regulatory asset, yes. We're proposing to take out of the test period the O&M expenses associated with the implementation of Customer Connect and put those into a regulatory asset, defer those over a period of, I think we proposed over the life of the asset, so 15 years.
So is it fair to say that there's a direct link between that adjustment to the revenue requirement and the establishment of the regulatory asset?
Yes, absolutely.
So if the settlement agreement wasn't approved in totality, and for instance, the regulatory asset wasn't approved, would that then require an upward adjustment to the revenue requirement?
Yes, definitely. If the regulatory asset were denied, we would need those expenses to remain in the test period, and the revenue requirement would need to be adjusted from what we agreed to in the stipulation.
Okay. And how long have you been engaged in rate making and around rate making procedures?
I've been in the rates and regulatory department since 2015, so 6 years-ish.
Okay. In your opinion, is the settlement as a whole fair, just, and reasonable?
Yes, absolutely.
Thank you.
Mr. Cook, Ms. Vinsel, do you have any follow-up after redirect?
No questions for the AG.
No further questions from staff.
Anything else, Commissioner? Nothing from me either.
Your Honor, our plan was to recall Ms. Lawler at the end of the hearing because there may be other topics that are deferred to her, so we'd ask that she be excused subject to recall.
No? Any objections?
No objection.
I figured there wouldn't be. That's fine with me, too.
Thank you.
Thank you,
Thank
Ms.
you.
Lawler. Mr. D'Ascenzo, now that we have you back, would you like to call your next witness?
Yes, please. For our next witness, we would call Brian Weisker.
Mr. Weisker, if you could raise your right hand, please. Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury?
I do.
Could you please state your name and address for the record?
It's Brian Robert Weisker, 4720 Piedmont Road Drive, Charlotte, North Carolina, 28210.
Counsel, you may examine the witness.
Thank you, Your Honor. Good morning, Mr. Weisker.
Good morning.
Would you please state your position with the company for the record?
I am a Senior Vice President and Chief Operations Officer for the Natural Gas Business Unit.
And Mr. Weisker, did you cause to file direct testimony and responses to data requests in this proceeding?
I did.
And do you have copies of those documents in front of you?
I do.
Do you have any other documents in front of you?
I have also I have a copy of the stipulation agreement as well.
Okay. And do you have any changes or corrections to any of those documents?
I do not.
So if you were asked those same questions today, would your responses be the same?
They would.
And is it your intention that those documents be submitted into the record of this proceeding?
Yes, please.
Thank you. Your Honor, the witness is available for cross-examination.
And Mr. Cook, do you have any questions on behalf of the Attorney General?
The AG has no questions.
Thank you. Ms. Vinsel?
Staff has a few questions. Good morning, Mr. Weiss.
Good morning.
I know that you know that I'm going to ask about the Femce requirements, but let me start with a couple more global pieces of that.
Okay.
Have there been any significant changes to the Femce regulations since the filing of this case?
Since the filing of this case?
Yes.
There has not since the filing of the case.
And are there any Femce advisory bulletins or any other directives mandating the replacement of the A.O. Smith pipe?
There are specifically mandating the replacement.
Yes.
No, the Femce regulations they guide us towards assessing the threats of the pipe, and that's what's driving us towards the replacement.
Has Duke's transmission integrity management plan monitoring the AM07 line led to the reduction in the maximum allowable operating pressure, or MAOP, or actual operating pressure?
So our assessment, I'll say from an assessment standpoint, we have to identify the threats that exist on a given pipe. And so for this pipe AM07, there are threats to external and internal corrosion, there's threats for excavation damage, there are threats, manufacturing and construction defects very specific to this pipe, and as well with the new gas transmission rule, there's a new threat, an LFERW, low frequency electric resistance welded, has to do with the seam weld on the pipe. Those threats all exist, and because of those threats, we have to assess the pipeline for those threats, and we either have to do that via an inline inspection, which this pipeline is not capable of being inline inspected, or via a pressure test, which would require you to take the pipe out of service in order for you to do that. We cannot take this pipeline out of service. It's the backbone. It feeds the entire Duke Energy Kentucky system. And because of that, that's what's leading us towards the replacement of it. Specific to, if you did an inline inspection and find defects, that would lead you to a pressure reduction. If you find defects, you take a 20% pressure reduction. But we can't do an inline inspection, so therefore we haven't taken a pressure reduction.
To make sure that I understand, Duke has taken pressure reductions? Or it would only be if there was the inline inspection?
If we were capable of doing an inline inspection, and you find defects, that would require a 20% pressure reduction until those defects are corrected.
Thank you, I understand that. Have there been any integrity digs to investigate any anomalies with the AM07 line?
There would be historically been integrity digs that would have been looking based on our ECDA, external corrosion direct assessment, that would have been performed, but that's looking just specifically at external corrosion I don't know the specific, I don't have the specifics of any of those specific digs that have historically been done.
What we will do is ask as a post-hearing data request, any records regarding those.
Okay.
Can you describe how other Duke affiliates have handled replacement of the A.O. Smith pipelines? And if you cannot, that,
I cannot, because I don't know where we've addressed any other A.O. Smith piping within our system.
and my last three questions are all going to be post-hearing data requests, but I'll let you know now. What we'd like to know is what the MAOP for the AM07 line has been from installation date to the present, what the actual operating pressure has been, and the leak history for the line. So that will be coming in a post-hearing data request.
Understand?
And staff has no further questions.
You, Commissioner Butler?
No questions.
Okay, I do have a few.
Okay.
I know you've heard my other questions.
I have.
Can you just explain for me what's going to qualify for this rider?
So we specifically the AM07 pipeline replacement project, and then it would be any other integrity management pipeline replacement projects that would be identified. So an example would be when we would do an inline inspection of any of our other additional pipelines that may identify a defect that we have to replace that section of pipe. That would be an example of something else that would potentially apply in this rider.
Okay, and I believe that Ms. Lawler testified that at this time, Duke doesn't project any other projects that it currently knows of that would qualify for this rider. Is that correct?
That is correct at this time.
Are there any other pipelines in Duke, Kentucky's jurisdiction, or that Duke, Kentucky has that are similar to AM07?
So we have, I would say just from our transmission pipelines in Duke Energy, Kentucky, the other ones of substantial length are our UL06 pipeline, our AM00B, and UL47. Those three make up the remainder of the majority of our transmission pipeline. So those would be the areas where we would have potential for inspection that would lead us to potentially having to replace a section of that pipeline.
Do they pose the same threat as AM07?
They have different threats, different vintage of pipe. They're all newer pipelines, so the likelihood of the same threat, they do not.
Okay, so they would not include any of the A.O. Smith manufactured pipe?
That is correct.
Okay. As far as your projections for replacement of AM07, do you feel comfortable that the 5% cap will cover the cost?
I do, based on our current estimates of the 5 phases, I do believe that the 5% would cover it.
Okay. I think that is all the questions I've got. Do you have any redirect?
Yes, Your Honor. Mr. Weisker, a lot of conversation about the AM07 pipeline. Could you please just describe the AM07 pipeline, the length, the size, et cetera, for the record?
So it's a 17-mile pipeline in its total length. It's 24 inches in diameter. It runs from where AM07 ties to the transmission feed from the KOT transmission system, and it runs all through northern Kentucky all the way over to just north of the airport. And it is the feed. It's the main feed that feeds the entirety of our system. Everything that feeds up into Covington and Newport, everything that feeds down into the Boone County and all the other counties as far as Kenton County, Campbell County, all that, it feeds the entirety of our system.
Thank you. And I believe you had described it as the backbone of the system. Can you Explain what would happen if we had to take a pressure reduction on AM07. What would that do to our system?
If we had to take a pressure reduction on AM07 and go into the winter with that pressure reduction, it would have a significant impact as far as our ability to serve customers. You know, the system's designed for us to be able to support and deliver gas to our customers, and expecting that the AM07 pipeline is at its normal operating pressure. If it's going to have a 20% pressure reduction, it would have a significant impact on our capability to serve customers.
Could that lead to potential outages?
Yes, it definitely could lead to potential outages in cold weather.
Do you know approximately when AM07 was installed?
AM07 was installed and went into service in the 1955, 1956 timeframe.
And do you recall questions about the AO Smith pipe? And I believe it was counsel for staff that asked, whether any of our affiliates have dealt with this kind of pipe. Are you aware of any industry initiatives and other gas companies dealing with this type of pipe?
The industry guidance is that this pipe, it has known manufacturing and construction defects. The guidance is to the best you can, is to remove it from service and replace it.
Thank you. No further questions, Your Honor.
Mr. Cook, Ms. Vincel, any additional questions based on redirect?
No questions from the AG, Vice Chair.
No questions from commission staff.
Anything else, Commissioner? Okay, I think you may step down.
May the witness be excused, Your Honor?
Any objections?
No objection.
No objection.
Okay, he may be excused.
Thank you.
Thank you.
Let's try to get through at least one more witness before we take a short break.
There we go.
You may call your next witness.
Thank you, Your Honor. For our next witness, we call Dylan DeAscendis.
Mr. DeSendis, could you raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
And please state your name and address for the record.
Dylan DeAscendis, 3000 Atrium Way, Suite 200, Mount Laurel, New Jersey, 08054.
Okay, you may examine the witness.
Thank you, Your Honor. Good morning, Mr. DeAscendis.
Good morning.
Would you please state your full name, title, and position with your company for the record, please?
Sure, my name is Dylan W. DeAscendis. I'm a partner at Scott Madden, Inc., and my business address is 3000 Atrium Way, Suite 200, Mount Laurel, New Jersey, 08054.
And Mr. DeAscendis, did you cause to file direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
Yes,
And do you have those documents in front of you today?
I do.
Do you have any other documents in front of you?
I have Ms. Lawler's settlement testimony.
Okay. Do you have any changes or corrections to the documents that you are sponsoring?
I do not.
And so if you were asked those same questions today, then would your responses be the same?
They would.
And is it your intention that those documents be submitted into the record of this proceeding?
Yes.
Thank you. Your Honor, the witness is available for cross-examination.
Mr. Cook, anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Vincel, any questions?
Now, staff has no questions.
Commissioner?
No questions.
And I have no questions.
All right. I have no question.
Thank you, sir. You may step down.
Have a good morning.
Thanks, you too.
Yeah.
May the witness be excused, Your Honor?
Any objections?
No objection.
He may.
No objection.
All right.
Well, that went quickly, so Did we want to try to get one more in before a break? We've only been going about 50 minutes. Ms. Honker, you may call your witness when you're prepared. Don't want to rush you. You can get settled if you'd like.
We call Chris Bowers to the stand.
Mr. Bauer, could you please raise your right hand? And do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
I do.
Could you please state your name and address for the record?
Sure, my name is Chris R. Bauer. My business address is 400 South Tryon Street, Charlotte, North Carolina, 28202.
Counsel, you may examine the witness.
Good morning.
Good morning.
Can you please state your title for me?
Sure, I am the Director of Corporate Finance. I'm also the Assistant Treasurer of the company.
And did you cause to file direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
Yes, I did.
Do you have any corrections to make to any of those documents?
No, I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, they would.
And did you bring any materials with you to the stand?
I did. I brought with me my direct and rebuttal testimony as well as supporting financial schedules that I sponsored or co-sponsored.
Okay. And is it your desire and intent to incorporate those documents into the record of this proceeding?
Yes.
The witness is available for cross.
Mr. Cook, do you have anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Fensel?
Yes, just a few questions. Good morning, Mr. Bauer.
Good morning.
My first group of questions is about the $50 million unsecured debentures that Duke had planned to get financing for in September 2021.
Yes.
And in your testimony, it's correct that Duke ceased all marketing efforts for that.
That is correct.
And in your testimony, you discussed three particular reasons for it, and I'd like to walk through each of those and have you explain it a little further.
Absolutely. I think that's important.
Thank you. So one of the reasons for the decision had to do with the ESG, the environmental, social, and corporate governance mandates and new policies. Could you expand upon that, please?
Absolutely. So I've been around the capital markets for a number of years. This has been a trend in the capital markets that I've seen pick up a lot of momentum specifically in the last couple of years. What it is really with these investors is it's a mandate, frankly, from their credit committees as they think about the companies that they buy and hold in their portfolios. They think a lot about the financial and the business risk that they hold. And ESG has become an investment thesis. It's a way that investors think about companies in a way that says the environmental, the social, and the corporate governance factors for companies that demonstrate higher levels of success in these areas, the return from those investments tend to trend higher over time. So that's the thesis. And so in that, a lot of investment firms have started putting in certain limitations and saying for companies that don't meet certain thresholds, we're no longer allowed to invest or hold the securities of those companies. And so we see that in a lot of time on the equity side. So when we think about selling equity, that's a very common theme. But now we're starting to see it on the fixed income side as well. And this year in particular, when we went to market with Duke Energy Kentucky, that was the number one issue that we faced was investors that typically buy Duke Energy Kentucky bonds. The feedback that we received was, listen, we have new ESG mandates on the portfolio. We're actually not allowed to buy those bonds any longer.
Thank you.
Sure.
And another reason that you referenced had to do with portfolio limits to Duke Kentucky. And could you expand upon that also?
Sure. That's when you think about diversification within a portfolio, any portfolio manager can only have so many bonds of a specific company within their portfolio. And so Duke Energy Kentucky over the past few years has issued quite a bit of debt as they've gone through this capital program. And so just due to the size of Duke Energy Kentucky, there are certain portfolio limits. And so some investors that were there that we reached out to talk about the bonds this year just said, I can't buy any more Duke Energy Kentucky bonds. I would not say that that was one of the primary reasons, but it was a limitation that was expressed this year.
And then the third and last reason that you referenced was due to proposed incremental restrictive covenants. Can you explain what those are and how they're restrictive to Duke, Kentucky?
Yeah, sure, no problem. And so when we think about the overall group of investors that we reached out to, the ESG mandates shrank that pool quite a bit. The portfolio limits shrank the pool even a little bit smaller. But for the investors that were left that said we could buy bonds of Duke Energy Kentucky, but if we did buy the bonds from you this year, we would expect certain covenants to be added or a new covenant package to the offering documents. Some of them were pretty easy. Some of them were a bit more restrictive. What some of those could be, it could just be, how they calculate final interest payments, towards the maturity of the bonds. That's pretty easy. Certain debt to cap ratios starts to get a bit more restrictive in terms of what you're allowed to have within your capital structure. That limits the financial flexibility of the company. And then there was a change of control provision that really starts to limit the strategic flexibility of the utility. And what that change of control would have done is if there was something that changed the ownership structure of Duke Energy Kentucky, then those bonds would then be puttable, means the investors could put them back to the utility. And that's a provision that we don't have in any of our offering documents at any of our utilities within the whole Duke Energy portfolio. And the risk really becomes if you start adding certain provisions like that to this set of debentures that we would have issued, then existing investors could also say, well, now I really want that provision in my historical debentures as well, and then going forward. So we felt like at the time that we were in this year, we didn't need to concede to those types of provisions or covenants in the current year. There was a market available to us in the bank market that we could secure a 2-year term loan. And so we thought, for now, this is a really good opportunity for us to secure a very low cost of capital for the next 2 years. And then we can think as a utility about how will we market Duke Energy Kentucky going forward. And so I'll go back one bit on the ESG. One of the issues is just we operate one coal plant here, and that was a hard story to tell with investors. But one of the themes that came out of it was we could buy Kentucky, but we need a very clear story and a clear path forward in terms of what will the generation portfolio look like. And so we felt over the next couple of years that's a story that could emerge, and so that gives us additional opportunity to market, potentially a different story at Kentucky the next time we come to the capital markets.
Thank you.
Sure.
When you mentioned the 2-year financing, the bridge financing, can you tell us what the status is of that effort?
Sure. We closed that bridge financing, I believe, about a week and a half ago. And so that was it's a 2-year term loan that's a floating rate security with a set spread over SOFR, which is the benchmark rate that we chose.
And you said it was a floating rate. Can you tell us what the range is? Is there a range?
Yes, it's a set spread. I believe it's 65 basis points over SOFR. And so you would take that SOFR rate and then you would apply the fixed spread to that rate over a period of time.
And you said it closed about a week ago?
I think it was about a week and a half ago that we closed that term loan.
Just to put this in here, one moment, please. Thank you, I had to consult. Just one last question about the money pool borrowings.
Sure.
As you noted in your testimony, it was elevated over the past 5 years due to higher capital spending. And just to confirm that Duke does not anticipate any large capital projects during the forecasted test year that would require an increase in the money pool borrowings. Is that correct?
That's correct.
Staff has nothing further.
Commissioner Butler?
No questions.
I don't have any questions for this witness. Do you have any redirect?
I do not.
Okay. Anyone else have anything before we let this witness step down?
No questions from the AG.
May he be excused?
Any objection to him being excused?
No objection.
No objection.
Okay. You may be excused, sir.
Thank you.
Thank you. Well, we've been going about an hour. Do we want to take about a 10-minute break? And we'll come back at, let's say quarter after. We are back on the record in 2021-00190, the electronic application of Duke Energy Kentucky. Ms. Honaker, you may call your next witness.
Brian Mangus.
What was his name, Allison?
Brian Mangus, M-A-N-G-E-S.
Could you please raise your right hand, and do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
And could you please state your name and address for the record?
Sure. Brian Mangus, 4720 Piedmont Road Drive, Charlotte, North Carolina, 28210.
Ms. Honaker, you may examine the witness.
Good morning.
Morning.
Can you state your title for me, please?
Sure. I'm the Director of Accounting for Gas, Utilities, and Infrastructure.
And are you the same Brian Mangus that filed testimony and responses to data requests in this proceeding?
Yes, I am.
Do you have any corrections or additions to make to any of those documents?
I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes.
And could you tell me what you brought to the stand with you today?
I have a copy of my filed testimony as well as data requests and exhibits that I sponsor.
And is it your desire and intent to incorporate your testimony and data request responses into the record of this proceeding?
Yes, it is.
Witness is available for cross.
Mr. Cook, do you have anything on behalf of the Attorney General?
Your Honor, the AG has no questions for this witness.
And Ms. Fensel?
Staff has no questions.
Commissioner? I have no questions.
All right.
Can the witness be excused?
Any objections?
No objections.
No objection.
Okay, you may be excused.
Thank you.
Thank you, sir.
Thank you.
And whenever you get settled, you may call your next witness, Mr. Sanford.
Thank you, Your Honor. We'd like to call Ms. Motsinger to the stand, please.
Please, I'm sorry.
Abby Motsinger.
A lot of names and we're going quick, so. Ms. Motsinger, could you please raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Could you please state your name and address for the record?
Abby Matzinger, 550 South Tryon Street, Charlotte, North Carolina, 28202.
Okay, Mr. Sanford, you may examine the witness.
Thank you, Your Honor. Ms. Motsinger, would you please tell us what's your title?
Director of Jurisdictional Forecasting.
Okay. And did you cause certain testimony and responses to data requests to be filed in the record of this case?
Yes.
Do you have any additions, corrections, changes to that testimony or data request responses?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
And is it your desire and intent to have that testimony and responses to data requests incorporated into the record of this hearing?
Yes.
Did you happen to bring any materials to the witness stand with you today?
Yes. I brought my testimony, data request for which I'm responsible, and a copy of Ms. Lawler's testimony related to the stipulation.
Okay. Thank you, Your Honor. Attend to the witness for cross-examination.
Okay, Mr. Cook, anything on behalf of the Attorney General?
The AG has no questions.
Ms. Fensel?
Staff has no questions.
Commissioner? No questions. And I have no questions.
Thank you, Your Honor. We ask the witness to be excused.
Any objections?
No objection.
Thank you,
No
Ms.
objection.
Motsinger. You may be excused. And Mr. Sanford, whenever you are ready, you may call your next witness.
We'd like to call Mr. David Rayford, please. I'm sorry, I went out of order. Mr. John Panizza.
John.
Panizza, yes.
Is he in the?
Yes, he's
Okay.
right here. Coming from door number 2.
Okay, Mr. Panizza, could you you already have raised your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Sure. John Panizza. My address is 550 South Tryon Street, Charlotte, North Carolina, 28202.
Mr. Sanford, you may examine the witness.
Thank you, Your Honor. Good morning, Mr. Panizza. Could you please state your name, or your title for the record?
Director, Tax Operations.
Okay. Did you cause certain testimony responses to data requests to be filed in the record of this proceeding?
Yes.
And do you have any edits, changes, corrections, or additions to that testimony or responses to data requests?
No.
If I were to ask you the same questions, would your answers be the same?
Yes, they would.
Is it your desire and intent to have that testimony and your responses to data requests be incorporated into the record of this hearing?
Yes, it is.
Did you happen to bring any materials to the witness stand with you this morning?
I have not.
Your Honor, attend to the witness for cross-examination.
Mr. Cook, do you have any questions on behalf of the Attorney General?
No questions, Your Honor.
Ms. Vinsel, any questions?
No questions.
Commissioner Butler, any questions?
Questions?
I have no questions.
Your Honor, I'd ask this witness to be excused then.
Any objections to this witness being excused?
No objections.
No objection.
You may be excused, sir. Thank you so much.
Thank you.
Ms. Honker, when you get settled, you can call your witness.
We call David Rayford to the stand.
Okay, Mr. Rayford, could you please raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I did.
Okay, please state your name and address for the record.
This is David G. Rayford, 550 South Tryon, Charlotte, North Carolina, 28202.
Ms. Honker, you may examine the witness.
Good morning.
Good morning.
Can you please state your title for the record?
Yes, I'm the Asset Accounting Manager.
And are you the same David Rayford that filed direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
Yes, I am.
Do you have any additions or corrections to make to any of those documents?
No, I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, they would.
And did you bring any materials with you to the witness stand?
Yes, I did.
Okay, can you tell me what those are?
Yes, they are my direct testimony, my rebuttal testimony, as well as the exhibits and data requests that I sponsored.
Okay. And is it your desire and intent to incorporate those documents into the record of this proceeding?
Yes, it is.
The witness is available for cross?
Mr. Cook, do you have anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Vinsel?
Vice Chair, no questions from commission staff.
Commissioner Butler?
No questions.
And I have no questions.
May this witness be excused?
Any objections?
No objection.
No objection.
You may be excused, sir. Thank you.
We call Jeff Setzer. Want me to go out of order and call?
That's up to you. I mean, we can wait if you would like. That's not a problem.
I can go ahead and call Dr. Ben Pasty to the stand. He was my next one anyway.
Okay. Mr. Pasty, could you raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I so swear.
Okay. And could you please state your name and address for the record?
Sure. My name is My name is Benjamin Pasty. My address is 12119 Kane Alexander Drive, Huntersville, North Carolina, 28078.
You may examine the witness.
Good morning.
Good morning.
Can you please state your title for the record?
My title is Lead Load Forecasting Analyst.
And are you the same Benjamin Pasty that filed direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
I am the same.
Do you have any additions or corrections to
I
make
have
to
no
any of
additions.
those? If I were to ask you those same questions today, would your answers be the same?
They would be the same.
Did you bring any materials with you to the witness stand today?
I did bring materials. I brought a binder that has testimony as well as responses to data requests that I've caused as part of this proceeding.
Okay. And is it your desire and intent to include those documents in the record of this proceeding?
It is.
The witness is available for cross.
Mr. Cook, do you have anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Vinsel, anything on behalf of staff?
No questions.
Commissioner Butler?
No questions.
I have no questions. Before you even ask, I'll just ask, does anyone have an objection to this witness being excused?
No objection.
No objection.
You may be excused, sir. Thank you.
Thank you. Call Jeff Setzer.
Mr. Setzer, could you please raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Could you please state your name and address for the record?
Jeffrey R. Setzer, 550 South Tryon Street, Charlotte, North Carolina, 28202.
Ms. Onager, you may examine the witness.
Can you please state your title for the record, Mr. Setzer?
Director, Allocations and Reporting.
And are you the same Jeff Setzer that filed direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
I am.
Do you have any additions or corrections to make to any of those?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
Did you bring any materials with you to the witness stand today?
I did not.
And is it your intent to incorporate the documents that you provided into the record of this proceeding?
It is.
The witness is available for cross.
Mr. Cook, do you have any questions on behalf of the Attorney General?
No questions, Your Honor.
Ms. Fensel, on behalf of staff?
No questions.
Commissioner Butler?
No questions.
I also have no questions. Does anyone have an objection to this witness being excused?
No objections.
No objection.
Thank you, sir.
Thank you.
You may step down and be
Thank you.
excused.
We call Jake Stewart.
Morning, Mr. Stewart. Could you please raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay, could you please state your name and address for the record?
Jake Stewart, 550 South Tryon Street, Charlotte, North Carolina, 28202.
And Ms. Honaker, you may examine the witness.
Good morning. Can you please state your title for the record?
Director of Health and Wellness.
And are you the same Jake Stewart that filed direct testimony, rebuttal testimony, and responses to data requests in this proceeding?
I am.
If I were to ask you those same questions today, would your responses be the same?
Yes.
Did you bring any materials with you to the witness stand?
I did. I brought my direct testimony and rebuttal testimony as well as various data requests that I sponsored or co-sponsored.
Okay. And is it your desire and intent to incorporate the documents you sponsored into the record of this proceeding?
Yes.
The witness is available for cross.
Mr. Cook, do you have any questions on behalf of the Attorney General?
No questions, Your Honor.
Ms. Fensel, do you have any questions?
Just a very few. Kind of feels like an end of a no-hitter here. In the settlement, the parties had agreed to remove 50% of the short-term incentive plan or expense from the revenue requirement. Is there any support in the record for removing only 50% of the short-term incentive compensation plan expense?
My understanding is because we had made a pro forma adjustment to remove the 50% associated with EPS, and then the settlement, there's an additional 50% settlement. I'm not aware of anything.
And from the original proposal, the 50% that represented EPS, that was from the performance measures, is that correct?
Correct. So there is a performance measure associated with EPS and the short-term incentive plan design.
Staff has nothing further.
Commissioner Butler?
No questions.
Okay, I do have a few questions. Explain to me what the EPS threshold is, just so I understand what we're talking about here.
So in previous conversation, there is an earnings per share goal within the overall short-term incentive plan design. So each goal or metric in the plan has a minimum, a target, a maximum value associated with it. So the EPS, just for clarification, the metric by itself has a minimum, target, and maximum. There is an EPS circuit breaker That's oftentimes referred to as a threshold that's in the plan as well.
So what do you mean by the threshold circuit breaker? What does that mean in practical terms?
Sure. So the EPS circuit breaker is meant to only really be used in the plan in very challenging years from a financial perspective. If we as a company do not achieve a certain earnings per share, if it's at or below the circuit breaker level, then that means the remainder of the metrics within the plan could be reduced based on that result. The reason that's in the plan is the earnings per share is a funding mechanism for the short-term incentive plan design. And so in those challenging years, that's a mechanism there that's will allow us to lower payouts if needed.
Okay, so when you say it would allow you to lower payouts, if you don't hit the circuit breaker, there would still be payouts?
If we exceed the circuit breaker, the metrics would pay out as they're achieved. So for example, operational excellence is another metric within the short-term incentive plan design. If we were to achieve 125% on that particular goal and we exceed the EPS circuit breaker, the circuit breaker does nothing to the plan in that situation. The payout would be based on that achievement of 125%.
And I believe you said, explain again, because I'm not sure I completely followed when you were discussing it with Ms. Fensel, the 50% and the reduction, how that was arrived at.
Sure. So if you think about the short-term incentive plan design as a pie, 50% of that pie is associated with earnings per share. So we have an actual earnings per share goal in the plan. That portion of the short-term incentive plan expense has been removed for recovery.
Okay, but with the circuit breaker, the other 50%, how is it affected by earnings per share, if at all?
Can you say the question one more time?
Okay.
I want to make sure I answer it correctly.
Of course. The other 50% that is based on these other metrics, I think you had explained one. I think operational excellence may have been the term you used. Is it affected at all by earnings per share? Or is it paid if that metric is achieved no matter what?
So the earnings per share is also the same EPS with the circuit breaker. So you can think about the circuit breaker as separate from the 50% earnings per share that I spoke about just a minute ago. If we do not exceed the EPS circuit breaker, it can have an impact on the other metrics of a plan. It could reduce those payouts.
Okay. I think that is my last question. Do you have any redirect, Ms. Honaker?
I don't think so. No.
Anyone else have any follow-up, Mr. Cook?
No questions.
Ms. Fensel?
No more questions.
Okay. Any objection to this witness being excused?
No objection.
No objection.
You may be excused, sir. Thank you.
We'll call Leslie Quick.
What's her last name?
Quick. Q-U-I-C-K.
Ms. Quick, could you please raise your right hand? And do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
I do.
And could you please state your name and address for the record?
Leslie Quick, 400 South Trowland, Charlotte, North Carolina, 28202.
Ms. Hunter, you may examine the witness.
Good morning. Can you please state your title for the record?
I'm Vice President of Strategic Planning, Governance, and Technology within our Customer Services Organization.
And are you the same Leslie Quick that filed testimony and responses to data requests in this proceeding?
Yes.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Do you have any additions or corrections to make to any of those?
No.
Did you bring any materials with you to the stand today?
Yes.
And what did you bring?
I have my direct testimony and then data request responses.
And is it your desire and intent to incorporate those items into the record of this proceeding?
Yes.
The witness is available for cross.
Mr. Cook, do you have any questions on behalf of the Attorney General?
The AG has no questions.
And Ms. Bensel, on behalf of staff?
Yes, I have a few questions. Good morning, Ms. Quick.
Good morning.
I'd like to start with, during this proceeding in data requests, Commission staff had asked about the information collected from customers when they apply for service and in regards to the credit check piece of it. So it's correct right now that Duke collects a social security number, a driver's license, some other particular identification number for the purposes, perhaps not the sole purpose, but for the purpose of running a credit check. Is that correct?
Yes.
So if a customer either cannot or does not want to give one of, for example, social security number, driver's license, what are the alternatives for that customer?
Sure. So there are customers that don't necessarily have a social security number or a driver's license number. And what we do in those cases is we work with a third-party vendor to ask the customer other questions that will imply that they are the correct customer of record that they are saying they are. So we would work with a third party to get that information and confirm that it is the right customer with the right name.
And when you check with this third-party vendor, can you do that while the customer is there applying for service?
Yes. Yep.
So a customer would not have to, say, come back or call again, or however, they contact you to start service?
Right.
And how does the customer know that those options are available to them? Like, walk me through the process.
Sure. So when a customer calls to start service, we would have to request this information. So we usually ask the customer if they have a social security number or a driver's license number that they can provide us. That way we can get our third-party credit check vendor to confirm that the customer is who the customer is saying by name. And if the customer was talking to a specialist and they were unable to provide that information, the specialist would then say, well, we can work with other information, but we have to work with our third-party vendor to actually confirm the identity in compliance with VACTA rules. So we would work with that third party and the customer to confirm that that customer is who they say they are.
And without going too far into the weeds, I'm thinking of, for example, those classic questions you get to confirm your identity, you know, which of these addresses did you live in the past, or did you live in any of these addresses in the past, that type of information.
Right, yes, like what city were you born in, maybe what address did you live in prior to the new address, et cetera, yes.
Is a prospective customer ever refused service for their either inability or unwillingness to provide a social security number or driver's license?
I'm going to say no on that. We would work with the customer to confirm identity. I mean, we do have customers who can call us and try to set up service in someone else's name, so we have to, by law, confirm that that customer is who they say they are. But we would work with the customer to make sure we started service for that customer.
And just to confirm this, I will let you know, as a post-hearing data request, staff will be asking if there are any customers that were denied service for failure to provide that information.
Okay.
So when Duke gathers this information, such as the social security number, driver's license, what sort of security how does Duke treat those numbers?
So we do encrypt the data in our systems, so that a specialist, for example, couldn't access the billing system and see your social security number, et cetera. So all that information is protected and encrypted within our billing system.
Does Duke charge customers for disconnecting gas service? Is there a disconnection fee? We know there's a reconnection fee. Is there a disconnection fee?
I do not believe there is a disconnection fee.
And acknowledging that you said you don't believe that there is a $15 field collection charge, and correct me if I'm wrong here, that fee is charged if someone from Duke goes out to collect or to disconnect a customer, and while that representative is there on site, that customer pays whatever amount is due. So that, is it correct that Duke then charges $15 for that, basically that visit to go out that ends up collecting the money?
I'm not familiar with that fee, but I am familiar with the reconnection fee, so I'm not sure if there's another witness that maybe can address the disconnection fee.
Okay. I will ask Duke's counsel if there's someone else at a break. I won't go through all this, but we do have a few other post-hearing data requests that we'll have in regards to disconnection and reconnection policies. Staff has nothing further.
Commissioner Butler?
Thank you. I just have a couple of questions. About your reconnection fee, you use a third party to do this, to reconnect?
Our field technicians would do the reconnection, so some of those I think are outsourced and some are within the house.
So does your reconnection fee reflect just what is charged for that, or the staff cost, or does it have administration costs in it as well?
Don't believe we're asking to change the reconnect fee in this rate case, and I'm not sure I know all the details within that reconnect fee. Maybe another witness.
Okay, thank you. My other question was about the field collection charge, but there's another person for that, correct?
Yes, we believe it'll be Jeff Kern.
Okay. Thank you.
This may also be for Mr. Kern, but do you know generally about reconnection fees, not the amount and how it's figured, but is it predominantly after someone's been shut off for non-payment, or are there people who periodically just disconnect, say for the summer, and then want to reconnect?
We do have customers who will disconnect during the summer and then reconnect, and they do pay the reconnection fee, just like a customer would if they got disconnected for non-payment, they would pay the reconnection fee.
Do you happen to know any percentage, or can you allocate, even roughly, how much of it is how much of your reconnections are attributable to non-payment that has been cured, and then how much of the voluntary disconnect and reconnect?
I do not have that information with me.
Okay. That's my only questions. Any redirect? No. Anyone else have any follow-up?
No follow-up, but Vice Chair, I want to let you know that staff is asking a post-hearing data request in regard to percentages about disconnect reconnects.
Okay, thank you. Does anyone have any objections to this witness being excused?
No objection.
No objections.
Thank you. You may be excused. Thank you. And when you get settled, there's no rush. You may call your next witness, Mr. DiAsenzo.
Thank you, Your Honor. For our next witness, we call Ms. Retha Hunsaker.
Would you please raise your right hand? And do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
Yes, I do.
And could you please state your name and address for the record?
It's Retha Hunsaker, 400 South Tryon, Charlotte, North Carolina.
And you may examine the witness.
Thank you, Your Honor. Good morning. It's still morning, Ms. Hunsaker. Would you please state your name, business address, and position with the company for the record, please?
Absolutely. It's Retha Hunsaker, 400 South Tryon, Charlotte, North Carolina, 28202. My title is Vice President, Customer Connect Solutions.
Thank you. And did you cause to file direct testimony and responses to data requests in this proceeding?
I did.
And do you have those documents in front of you?
Yes, I have my direct testimony and my data requests.
Great. Do you have any changes or corrections to any of those documents?
No, I do not.
So if you were asked those same questions today, your answers would be the same?
Yes, they would.
And is it your intention that those documents be submitted to the record of this proceeding?
Yes.
All right. Thank you, Your Honor. The witness is available for cross-examination.
Thanks. Mr. Cook, do you have any questions on behalf of the Attorney General?
The AG has no questions, Your Honor.
Thank you. Ms. Fensel, anything on behalf of staff?
The staff has no questions.
Commissioner Butler?
No questions.
And I have no questions. Any objections to this witness being excused?
No objections.
No objection.
Thank you, Ms. Hunsaker.
All right.
You may be excused.
Thank you.
Morning, Your Honor, again.
Good morning again.
Jay Brown, if I could.
Of course. Mr. Brown, if when you're settled, you could raise your right hand. Do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
I do.
Could you please state your name and address for the record?
My name is Jay Brown. My address is 139 East 4th Street, Cincinnati, Ohio, 45202.
Hey, you may examine the witness.
Thank you, Your Honor. Mr. Brown, would you please tell us what your title is?
Director of Rates and Regulatory Planning.
And did you call certain testimony and responses to data requests to be filed in the record of this proceeding?
I did.
And do you have any additions, changes, edits, or corrections to that testimony or data request responses?
I do. In my rebuttal testimony, I have a typo on page 10, line 3. There is a T that needs to be stricken from that.
Okay, just for purposes of clarity, would you perhaps be willing to just read that sentence
Yep.
as corrected?
The sentence says, as I discussed later, based on the magnitude of the actual equity and debt balances compared to the equity and debt balances that were included in the 2018 rate case test year, T is clear that the company did not intentionally run a lean or common equity ratio. That T should be removed. So it should say, it is clear that the company did not intentionally.
And with that correction, if I were to ask you all the same questions, would your answers be the same?
Yes.
Is it your desire and intent to incorporate your testimony and responses to data requests into the record of this hearing?
Yes.
And what materials did you bring with you to the witness stand today?
My rebuttal testimony, my direct testimony, and the data responses that I sponsored or co-sponsored.
Your Honor, tender the witness for cross-examination.
Thanks. Mr. Cook, do you have anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Fensel, on behalf of staff?
No questions.
Commissioner Butler? I have no questions. Does anyone have an objection to this witness being excused?
No objections.
No objection.
Thank you. Thank you, sir. You may be excused.
Thank you.
Your Honor, our next witness would be Mr. Jim Zolkowski.
Could you please raise your right hand? And do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
And could you please state your name and address for the record?
My name is James Lukowski, 139 East 4th Street, Cincinnati, Ohio, 45202.
Thank you. You may examine the witness.
Thank you, Your Honor. Mr. Zakowski, could you please tell us what your title is with the company?
My title is Director of Rates and Regulatory Planning.
And did you cause certain testimony and responses to data requests to be filed in the record of this case?
Yes, I did.
Do you have any corrections, additions, changes, or edits to the testimony or data request responses?
No.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Is it your desire and intent to have that testimony and the responses to data requests incorporated into the record of this hearing?
Yes.
And what materials did you bring with you to the witness stand today?
I brought a copy of my direct testimony and also the responses to the data requests that I sponsored.
Your Honor, with that, I would tender the witness for cross-examination.
Thanks. Mr. Cook, do you have anything on behalf of the Attorney General?
No, the AG has no questions, Your Honor.
Thanks. Ms. Vinsel, on behalf of staff?
Yes, we have just a few things. Good morning.
Morning.
These are going to be asked as post-hearing data requests, but I want to get that in the record now. You sponsored Duke's response to staff's first request, item 52. We are going to ask that that be revised separately by year from 2016 to the current day regarding reconnections. And we have three things we're asking for. Reconnection after fraudulent use was discovered by a customer. A customer requested disconnection for which the customer then asked for reconnection within 12 months. And finally, enforcement of Duke's right to cancel the service agreement that's set forth in a specific part of the tariff. And all of that will be in a post-hearing data request.
Okay.
And then the second post-hearing data request we will have, we would like for Duke to provide a 100% demand cost of service study with all inputs updated based on the stipulation, and it would be in Excel format with all columns, rows, and formulas unprotected.
Okay. Is it all right or appropriate if I ask a question about that right now?
Yes, yes, please do. That would be helpful.
Would the, are you saying that all costs should be allocated on demand and no cost should be classified as customer related?
Mains. No, we're looking at mains.
Oh, just the mains?
Yes.
Okay. That's fine.
Staff has nothing further.
Commissioner Butler?
Yes. Would this be the correct place to ask about the field collection charge?
I sponsored some data requests regarding the field collection charges.
So is it correct to say that if you send an employee out to disconnect someone and they run out and say, oh no, here's the money, there's a $15 charge at that point?
That is correct. The field collection charges were applied in the event that a customer, or that the company rolled a truck and sent a premise worker out there to disconnect the customer. However, seeing the worker on site, the customer decided to pay their balance due right then and there. And so the company would then not disconnect, but would charge a field collection charge, which would offset somewhat the cost of rolling that truck.
So do you allow the customer to pay by check, or do they need to call in and pay by credit card, and then your customer service rep is notified from your call center?
I do not know how that works. I don't know if the workers are allowed to even handle cash or not.
That was my next question, is do workers accept cash? So maybe some follow-up questions will be coming your way for that, just how exactly that works.
That'd be good.
Okay, thank you.
Okay, I just have one probably simple question. The revenue allocation and rate design was not affected by the stipulation. The proposal is to keep it the same as what was in the application. Is that right?
Well, the revenue and the rate design was affected by the stipulation in that the stipulation contains a lower revenue requirement from what we filed. However, the revenue allocation that we filed as part of the stipulation, I think that was stipulation attachment D, did have the same general rate revenue allocation. I did do a new cost of service study that reflected the inputs and the items that were adjusted for the stipulation. And so we And all of that does appear in stipulation attachment D. So the revenue allocation should be similar, very similar to what was as filed, except for lower numbers. So I think that answers the question.
Okay, and all that's in attachment D?
Yes.
Okay, that's my only question. Do you have any redirect?
No redirect, Your Honor.
Okay, anyone else have anything?
Nothing further.
Any objection to this witness being excused?
No objection.
No objection.
Thank you, sir. You may be excused.
Thank you.
You may call your witness whenever you are settled.
All right, thank you, Your Honor. For our next witness, we call Mr. Jeff Kern.
Sorry about that.
That's okay. Could you please raise your right hand? And do you swear or affirm that the testimony you are about to give is true and correct under penalty of perjury?
I do.
And could you please state your name and address for the record?
Jeff Kern, 139 East 4th Street, Cincinnati, Ohio, 45202.
You may examine the witness.
Thank you, Your Honor. Good morning, Mr. Kern.
Good morning.
Would you please state your position with the company for the record?
Rates and Regulatory Strategy Manager.
And Mr. Kern, did you cause to file direct testimony and responses to data requests in
Yes,
this
I did.
proceeding? Do you have those documents in front of you?
Yes.
Do you have any other documents in front of you?
No.
Okay. Do you have any changes or corrections to those documents?
No, I do not.
So if you were asked those same questions at this moment, would your answers be the same?
Yes, they would.
And is it your intent that those documents be submitted into the record of this proceeding?
Yes, it is.
Thank you. Your Honor, the witness is available for cross-examination.
Thank you. Mr. Cook, do you have anything on behalf of the Attorney General?
No questions, Your Honor.
Ms. Fencel, on behalf of staff?
Yes, just a few questions. Good morning, Mr. Kern.
Good morning.
In follow-up to what I asked Ms. Quick, so if Duke, first of all, let me confirm, Duke does not charge a disconnect fee, correct?
That is correct.
So what is the justification for charging the field service, or excuse me, field collection charge if there is no disconnection fee?
Well, the field collection charge is, we've rolled the truck to go out and reconnect them. Or not, sorry, we've rolled the truck to disconnect them. And under normal circumstances, if they didn't pay that, that $15 fee, they would, we will ultimately have to roll a truck to reconnect them. And so I think the justification for that fee is that similar to when we roll a truck to reconnect somebody, we've rolled that truck to go out there, and there's a cost associated with that to disconnect them.
So let me see if I can tease that apart. So there's a $90 fee to reconnect.
Correct.
Does that $90 include both disconnection costs and reconnection costs?
It's the only fee that we charge, since we do not charge a disconnect fee, but it is the cost, that $90 cost is based on just the cost of rolling the truck to reconnect them.
But just to reconnect,
Right.
not to disconnect. So you're basically charging someone $15 to roll a truck out that you would not otherwise charge if you had disconnected.
Yes, I guess that's correct.
Staff has nothing further.
Mr. Butler?
No questions.
Okay. I have just one question. It's regarding the late payment charge. What is the late payment charge? I mean, I know what a late payment charge is. How much is the late payment charge?
I can look it up. I don't.
Is it a flat fee or is it a percentage?
I believe it's a flat fee. It's
Okay.
not-
How does Duke arrive at the amount of the late payment charge?
Well, Your Honor, we did not propose a change in late payment charge, so I did not do any calculation for that. So it actually would have been done from the last case, which I was not involved in. So I cannot honestly tell you how that was based in the last case, but it's something I guess we could answer in a post-hearing data request.
Okay, now, well, if you weren't involved in the last case and it was set there,
Right.
you can't answer it, so that's my only question. Anyone have any follow-up?
I do, but did you want to do redirect first? or-
Yes.
Oh, I am so sorry.
No worries. Mr. Kern, do you remember some questions about miscellaneous fees, the field reconnection fee, for example? Do you know whether those fees are currently included in miscellaneous revenue for the
Yes,
company?
they are.
So they act as an offset, is it fair to say they act as an offset to the company's revenue requirement?
Yes, that would be fair.
So if those fees were eliminated, what would that, in theory, do to the revenue requirement for the company?
In theory, that would make the revenue requirement go up.
Okay. And so those, strike that. Do you remember some questions about the late payment fee?
Yes.
And I believe you had mentioned that you thought it was a flat fee.
Right, but off the top of my head, I was guessing.
But that's in our tariffs, correct?
Right, right.
Do you have the tariffs in front
Yes,
of
I
you?
do.
Would you just mind looking for clarity of the record?
Okay. Unfortunately, I don't know off the top of my head which, where in the tariff that is.
And that's fair, but it would be in our tariffs, correct?
Yes.
Do you know whether there were data requests in this case about?
There have not been any, at least directed towards me. I did not respond to any data requests about the late payment charge.
Is there another witness in this case that if data requests were to have been issued, would have been responsible for those?
I would imagine Ms. Quick.
Thank you. No further questions.
Any follow-up?
I do have a follow-up, but also I'll follow up to this line of question, just to make sure it's in the record, that in fact, Ms. Quick did answer questions staff asked several times about the late payment fee component. Ms. Quick did answer those questions, well, sponsored the response. To follow up to something that Commissioner Butler had asked about, do you know, when a Duke employee collects the money on a field collection charge, can the employee accept cash, checks, a credit card number?
That, I do not know that.
That was my follow-up question. No further questions.
Yeah, Mr. Cook, did you have any follow-up questions?
No questions, Your Honor.
Thank you, Commissioner Butler. Anything else?
No, Your Honor.
Any objections to this witness being excused?
No objections.
No objection.
Thank you. Thank you, sir. You may be excused.
Your Honor, we propose to recall Ms. Lawler to the stand.
Okay, great. You are still under oath from earlier, so we don't need to re-swear you.
Thank you.
You may ask your questions.
Okay, I don't really have any questions to ask her specifically. She did, well, I may, let me ask. Ms. Law, you heard some questions a few minutes ago about the late payment charges.
I did.
Okay, and I think there was a little bit of confusion, but what is the late payment fee or charge?
So I believe the late payment fee that we assess is a 5% fee.
Okay.
5% of the overdue balance.
And do you happen to know any of the history on how that was established?
Yeah, so we did respond in some discovery questions. Ms. Quick did sponsor those, but if I recall, the 5% has been around for a very long time, I think maybe 40 years plus. It was approved by the commission some 40 years ago and maybe reapproved in, I think, 1992. We don't have a cost-based justification of the 5%, but it's just been one of those things that's been around for a very long time. And it is in our tariffs at 5%.
Yeah, I tender the witness for any other additional cross-examination there may be.
Mr. Cook, do you have any additional examination for this witness?
The AG has no questions, Your Honor.
Ms. Fensel?
Staff has no questions.
Commissioner Butler? No questions. I don't believe I have any questions either.
Okay. Thank you. May this witness be excused?
Any objections?
No objections.
No objection.
She may be excused. Thank you. Thank you. Do you have any further witnesses at this time?
That is our last witness. I've always asked for a directed verdict at this time, but I never seem to get one. But for the sake of the record, directed verdict, Your Honor.
You will not get that again. So denied, but I appreciate the...
You don't get what you don't ask for.
I appreciate the completeness of the record as a person who has been in your position. So. I know we probably have gotten through a little quicker than Mr. Cook and Mr. Horn than you all may have expected. Do you need a break before you put on your first witness? I think we've got plenty of time to do at least one of your witnesses before lunch.
Your Honor, I believe we are ready to go. Yeah, I think we could get at least one, if not both, in, depending on how many questions the company and staff and the commissioners may have.
Okay. Well, would you like to call your first witness?
Certainly. At this time, we will call Mr. Lane Collin.
Mr. Collin, if you would turn on your camera. Good morning, sir.
Good morning.
Could you please raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
And could you please state your name and address for the record?
Yes, my name is Lane Collin. My address is 35 Glen Lake Parkway, Roswell, Georgia 30075.
Counsel, you may examine the witness.
Thank you, Your Honor. Mr. Collin, could you state your title and your employer?
Yes, I am a vice president and principal with the firm of J. Kennedy and Associates Incorporated, and I'm an economic consulting and accounting and rate-making expert.
Thank you. Did you cause direct testimony and exhibits to be filed into the record of this case?
Yes.
Did you also cause responses to certain data requests to be filed?
Yes.
And do you have any additions or corrections to make to that testimony or responses to data requests?
I had corrections to a table on page 32 of my direct testimony, and those corrections have previously been filed by the AG into the record.
Okay. And if you were asked those same questions today, would your responses be the same?
Yes, they would.
Your Honor, Mr. Collin filed direct testimony on September 14, and the Attorney General filed a motion at that time seeking leave to file that corrected testimony. And at this time, we would like to ask the Commission to grant that motion.
No objection, right?
No objection.
Okay, we'll make sure we get a written order out on that, but that is granted.
Thank you, Your Honor. And with that, I tendered the witness for cross.
Mr. Sanford, do you have any cross-examination for this witness?
Just have one question here. Good morning, Mr. Cullen. How are you today?
Good morning.
I guess two questions. You've reviewed the terms of the stipulation and settlement agreement, correct?
That's correct.
Viewed in its totality, is it a fair, just, and reasonable outcome in your opinion?
Yes.
Thank you, Your Honor.
Okay, Ms. Vinsel?
Staff has no questions.
Commissioner Butler?
No questions.
Okay. I have a couple of questions, Mr. Collin. First, on the short-term incentive plan. I believe that you had originally proposed removing all of that from the revenue. Is that correct?
Yes, that's correct.
And the settlement cuts it back to 50%. Is that correct?
Yes.
Do you agree with that 50%?
Well, I think you have to look at the totality of the settlement agreement, but if we were litigating just the one issue, my recommendation was 100% removal. But there was a lot of give and take in the settlement discussions, and that is reflected in the settlement agreement itself.
Okay.
So, from the overall perspective, I definitely agree with that.
Okay, and what was your justification for asking for the 100% removal?
Essentially, the earnings per share metric is a threshold for funding the short-term incentive compensation. And the Commission has in the past denied recovery of short-term incentive compensation, other incentive compensation expense on a number of bases, but principally on the argument that it is tied to the financial performance either of the utility or of the utility's parent company. And the disallowances ordered by the Commission have covered not only funding requirements, but also earnings per share, total shareholder return as performance metrics within an incentive compensation plan. So primarily it was based upon Commission precedent.
Do you believe that there is a justification for removing only 50% that is consistent with Commission precedent?
I do, because the Commission has been a little bit around the map on the issue of financial metrics for funding. In some cases, they found that the financial metrics for funding don't disqualify the short-term incentive compensation expense, only if it is an actual performance metric as opposed to a circuit breaker. In other words, circuit breaker for funding purposes. So there is some ambiguity or, a variety of Commission decisions in prior cases. The most recent one shows 100% removal for financial metrics as thresholds or as performance metrics. But given the totality of the Commission's decisions, the range of those decisions, and then the overall result of the settlement, I believe it is a reasonable resolution to just do 50%.
Okay. So you don't believe it is necessarily inconsistent with Commission precedent? Is that
No,
right?
I don't.
Okay. The pipeline modernization mechanism rider, do you have any opinions about that?
I do. It addresses some of the concerns that I laid out in my direct testimony. One of the concerns was with respect to the company's proposal for federal and state income tax rate changes. So that has been removed from what previously had been proposed by the company as the GMA, the governmental mandates rider. And so the proposed PMM addresses that simply by removing it. And then some of my other criticisms were the fact that it wasn't sufficiently defined. The settlement for the PMM rider has a tighter definition in the sense that it's based upon the Femce requirements, doesn't leave that open-ended. So, and the company then bears the burden of proof with respect to that it is a PEMSA requirement and that it has acted reasonably and prudently to meet that requirement. And then there is a sunset provision. That was another one of my criticisms, no expiration date on the rider. There's a 7-year sunset provision. And there is a reduction in the return on equity by comparison to the base revenue requirement. So by and large, most of my criticisms were addressed, again, within the totality of the settlement itself.
I have no further questions. Mr. Cook, do you have any redirect?
Just one question, Your Honor. So, Mr. Collin, if I understand correctly, then would it be your testimony that the company's proposal to replace the, let me rephrase, to place the cost of replacing this large transmission pipeline that was testified to earlier today, that placing those costs into the rider is not at all inconsistent with your testimony?
I think that's right, yes.
Okay, thank you. That's all the questions I had, Your Honor.
And Mr. Sanford, do you have any follow-up?
No questions, Your Honor.
Ms. Vincent?
No follow-up.
Commissioner Butler?
No.
Okay. I think we are done with Mr. Collin. Does anyone have an objection to Mr. Collin being excused?
No, ma'am.
No objection.
No objection.
Thank you, Mr. Collin. You can be excused.
Okay.
You're happy to hang out and watch the rest of the hearing if you'd like.
Okay, well, thank you very much.
Mr. Cook, would you like to call your next witness?
Yes, thank you, Your Honor. At this time, the Attorney General calls Mr. Richard Baudino.
Mr. Baldino, could you please raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
And could you please state your name and address for the record?
My name is Richard Baldino, and my business address is J. Kennedy & Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia.
Thank you. You may examine the witness, Mr. Cook.
Thank you. Mr. Baudino, could you state your employer, please?
Yes, I'm a consultant with J. Kennedy & Associates.
All right. And did you cause direct testimony and exhibits to be filed into the record of this case?
Yes, I did.
And did you also cause responses to certain data requests to be filed?
Yes, I did.
And do you have any additions or corrections to make to that testimony or responses to data requests?
No, I do not.
And if you were asked those same questions today, would your responses be the same?
They would.
Thank you. Your Honor, I tender the witness for cross.
Thank you, Mr. Cook. Mr. Sanford, do you have any questions for this witness?
Just the same questions I had for the prior witness, Your Honor.
Okay.
Mr. Baudino, have you had a chance to review the proposed stipulation and settlement agreement?
Yes, I do. I have it in front of me.
Okay, and within the scope of your expert testimony, are the terms of that stipulation and settlement agreement fair, just, and reasonable in your opinion?
Yeah, I think in total, yes, it represents a reasonable settlement of the issues in this case.
Okay. Thank you, Your Honor.
Okay. Ms. Vincent, do you have anything on behalf of staff?
No questions.
Commissioner Butler?
No questions.
And I have no questions. Mr. Cook, do you have any redirect?
No, Your Honor.
Okay. Does anyone have an objection to this witness being excused?
No objections.
Mr. Sanford?
No objection.
No objection.
Hey, well, thank you, Mr. Baldino. You may be excused from the hearing.
Thank you very much.
Thank you. Mr. Cook, do you have any additional witnesses?
No, that's all the witnesses that the AG has, and that concludes the Attorney General's case in this matter.
Okay. Staff? Does staff have any witnesses?
And no witnesses.
Okay. Well, I think that is probably it then. And if my tally is correct, there were no exhibits entered this morning that were not already in the record. Is that correct?
Your Honor, we probably should admit the stipulation as a hearing exhibit. It's been previously filed, but I think that may be appropriate to do.
Okay.
Staff has no objection to that.
Okay.
No objection.
Then I guess we need to talk post-hearing.
Yes.
Do we have, I know staff has already indicated there will be some post-hearing data requests. When do you think you can get those out?
And if we could have until October 21st.
Okay. And then assuming October 21st, Mr. Sanford, how long do you believe that the company would need to
Could
respond?
we have at least 10 days to respond? 10 business days? 2 weeks?
Let's see. So that would put us around November 4th. Does that sound about right? Okay, so we will set that for November 4th. Did the parties wish to submit any post-hearing briefing?
I think we would like to just submit a very brief in support of the stipulation.
Okay. Would simultaneous briefs be okay here?
That would be fine.
Okay, how about, would November 10th work for the initial brief?
That would be fine.
Do the parties wish to have a response?
We will not need a response.
Okay. Well, just in case, we can go ahead and any post-hearing order will set a response brief due on November 22nd, should any party get the initial briefs and wish to file a response. Obviously, you don't have to file a response and say, I don't need a response. If we don't get one, we'll understand you're not filing one. And is there anything else we need to take up today while we're here?
Not aware of anything, Your Honor.
Staff is not aware of anything further.
Okay. Is there anything else, Mr. Cook or Mr. Horn from the Attorney General?
Cannot think of anything, Your Honor, and at this point, I don't think the Attorney General will be filing a brief, but just need to consult with co-counsel about that before I can say for sure.
Okay, that's fine, Mr. Cook. If you decide to, the order will allow it, and, but you're welcome to litigate your case as you wish.
Thank you very much.
Anything else, Commissioner Butler? No. Okay, well, unless there is anything else, I believe we can call this hearing adjourned. And since it's the first time I get to do this, we're adjourned.